that's why medical treatment has to be treated differently. Because anytime you exclude one harmful practice, you are by definition saying these things are allowed because they are not harmful, and these things are excluded because they are harmful. That's the driving force behind regulating the particular practice.
Let me ask you about the standing argument. There's a statute on books, and if it prohibits what the petitioner wants to do, why doesn't she have standing? Why is it an answer, well, we haven't prosecuted her or anybody else under this statute?
I think it would if she said that she wanted to do something that violated the statute. And I think there's just been an ambiguity that has persisted in this case. What I can say is if she does not want to engage in a therapy for the purpose of changing a minor's sexual orientation or gender identity, then she is not violating the statute.
Well, both the district court, which ruled for you, found standing, and the 10th Circuit, which ruled for you, found standing. And you didn't cross-appeal on those, and not that you had to, it's standing. You didn't even put a Roman numeral in your brief on it, or even a subsection. It's footnote 18 on page 23. That doesn't exactly suggest that you have great confidence in that argument, does it?
Well, we recognize we lost it twice. And again, it is the petitioner's burden, and it has been a persistent issue in the case, I think, in defining exactly what it is she wants to do. And to come back to this conduct point.
But if she does, consistent with a patient's, I'm reading the verified complaint, if I understand that to mean, paragraphs 86, 87, that she wishes to help clients who voluntarily come and with the desire to change their behaviors, expressions, attractions, and identity, then that would give her standing, wouldn't it?
Identity, yes.
Only identity.
The others not.
The others not because of your peculiar reading of the statute, but identity would. That would give her standing.
The change in sexual orientation or identity is the key to...
And that would give her standing?
That would.
Okay.
Because you're not disavowing that?
No.
Okay. So that settles the standing question.
Thank you, Counsel. Justice Thomas, anything further?
You rely on the history of regulating the medical profession quite a bit. What's the history of regulating therapists? When did that begin?
Right. So I would say mental health and healthcare delivered through words both were in full force at the founding of this country. At the time, that was done by people you might call physicians, and all of their practice was pretty much carried out through words and giving advice. As time went on and specialties developed further, and the mental health profession sort of came into existence, those same standards applied and governed psychologists and therapists. And then I would say the licensing of counselors as other professionals in the mental health field was sort of the second half of the 1900s.
With respect to this type of regulation that is a prior restraint on speech, what was the first example of that?
So, Justice Thomas, I want to push back on the notion that this is a prior restraint on speech. There's no enforcement of this law unless somebody files a complaint with petitioner's licensing board and she has an adjudicatory hearing and opportunity for judicial review and all those things. So it's like many other statutes in that way. It simply calls out a specific practice that violates the standard of care. And those types of statutes have been around for a very long time. They were in the late 1800s. Those types of statutes governed medical professionals and then have been added over time as the mental health profession has developed and governed mental health professionals in every state.
Justice Alito?
Your argument depends very heavily on the standard of care, which I take it is defined by a medical consensus. Is that correct?
That's correct.
Have there been occasions, I mean, the medical consensus is usually very reasonable and it's very important, but have there been times when the medical consensus has been politicized, has been taken over by ideology?
We have no facts about that in this case, but I wouldn't disagree that that's possible. And I think it's a really...
Isn't it a fact that it's happened in the past?
I think
Three generations of idiots are enough?
I think that's certainly a concern, and if there were evidence of that in the record as to whether or not there were a standard of care that wasn't really based on patient safety, that would be highly relevant evidence.
Well, isn't that a reason to apply First Amendment scrutiny when what is being regulated is pure speech and not just saying medical standard of care or medical consensus? That's the end of the day. Rational basis review, anything goes.
No, Your Honor, because again, when we're talking about words used to deliver medical treatment, those issues are the same whether you're talking about words being used or whether you're talking about medical practices that don't involve words. Those issues are the exact same. And there is nothing about this statute, for example, that stops anyone from sharing any opinion about conversion therapy or about how the consensus on that was reached. And again, in this case, there is just no evidence of any motive by either the Colorado legislature or any medical association to reach this conclusion on anything based on anything other than protection of minors and a decades-long record of research.
Was there a time when many medical professionals thought that certain people should not be permitted to procreate because they had low IQs?
I don't know that, but I will accept the premise.
I mean, was there a time when there were many medical professionals who thought that every child born with Down syndrome should be immediately put in an institution?
I don't know that, Your Honor.
Thank you.
Justice Sotomayor? Justice Kagan?
I could go back to your example about having high cholesterol and all the various things that a doctor could say. And I don't think, like, anybody wants to remove doctors from, liability or any kind of professional sanction for giving utterly wrong medical advice just because the giving of that advice involves words, right? So if the doctor said you can lower your cholesterol by going out and eating dessert every meal, we would think that was like not a good thing for a doctor to say, and we wouldn't say, oh, the First Amendment has something to do with this. But I guess I have this feeling that that's a different kind of case, that is a case where the speech is incidental to whatever conduct it is that the doctor is offering. Whether it's, you should take this pill or you should do these eating practices or so forth and so on. And are you saying that there's no distinction between what we're dealing with here and the range of things that a doctor can tell you in her office about what kind of care is appropriate for any particular condition?
I don't think there's any distinction because just like in the medical field, counseling is an evidence-based practice that petitioner trained for thousands of hours to be qualified to do. And her advice and counseling therapies, through her words, can be extremely harmful. And so there is no difference between that and the medical context. And I wanted to come back to the first part of your question about calling out a specific practice that violates the standard of care. This is a thing that legislatures do not irregularly when you have a practice that although it's ineffective or although it's harmful, it persists anyway. So for example, in Colorado, there's a specific provision that says it's unprofessional conduct for medical doctors to prescribe anabolic steroids for sports performance. Now, normally something like that might die out, but you can understand why there are cultural pressures that make this continue to be interesting to people, even when they know there's harm. And this has been the problem with conversion therapy. Although every theory that it's relied on has been debunked and debunked and debunked, people continue to seek it and to want it and to believe that they can make this change. And I think that's understandable. It's a challenge to find out that you're a gay or transgender person. And then finally, to the issue of regulating a specific practice, we cited you a couple of cases about this false memory recovery. So there was a practice going on with psychotherapists in the 1990s where they were using a therapy that was causing children to come up with false memories of sexual abuse. and there were several malpractice cases about it. That therapy died out on its own. But if it hadn't, and therapists had continued to do it, and again, it was done only with words, surely a state could step in and say, that's unprofessional conduct. And that's exactly what Colorado and 25 other states have done here.
Thank you.
Justice Gorsuch? Justice Kavanaugh? Justice Barrett?
What is your best evidence on this record, thinking about the application of strict scrutiny, that this kind of talk therapy by licensed professional, licensed therapists to minors causes harm?
Sure. I would direct you, Your Honor, to JA 64 through 74. And I do want to note this particular argument about this specific study came up for the first time at 10th Circuit oral argument. And I think had we had an opportunity, we could absolutely have put in even more evidence to nail this down in the district court. But if you look there, our expert walks through all of the research that's been done since 2009. Aversive practices have not been in use since the 1980s or before, so all of these studies do not concern aversive practices at all. And then I would direct you specifically to the Green study and the Turbin study. The Green study looked at 34,000 13 to 25-year-olds who had gone through conversion therapy, and after controlling for other factors, found there was a 2 times rate of attempted suicides among that group. And in the Turbin study, Dr. Turbin looked at 27,000 participants. This was specifically on gender identity change efforts, including people who had received those efforts under the age of 10. He looked specifically at childhood exposure and found association with adverse mental health outcomes in adulthood, including suicide ideation and attempts. This question about whether it's voluntary or not, that's just not an issue that had ever been raised to focus on. And especially with children under 10, I don't even know how you would assess that. I would also direct you to Dr. Turbin's amicus brief, though, where he further describes the techniques that he used in his study to show how much they would align with, I think, what petitioner would imagine that she would want to try to do. And then you have to put it in the context of people have been trying to do conversion therapy for 100 years with no record of success. There is no study, despite the fact that people tried to advance this practice, that has ever shown that it has any chance of being efficacious. And again, the harm from it comes not from the aversive practice, it comes from telling someone there's something innate about yourself you can change, and then you spend all kinds of time and effort trying to do that, and you fail.
But you bore the burden. She didn't have to show that it was efficacious, right? You had to show that it caused harm.
Right, but in light of 100 years of studies that all point in the same direction with no efficaciousness and evidence of significant risk of harm, we think we amply carried that burden.
Tell me more. You said that in the 10th Circuit you wished, because if you had been back before the district court, you could have introduced more evidence. Did you not? It was a PI hearing. Why didn't you have the opportunity to introduce all the evidence you wanted to?
There was no hearing. We filed a response in response to petitioner's brief where she had no evidence. We put in a 60-page expert declaration covering all of this, and including not just the studies, but the fact that all of the theories underlying conversion therapy have been debunked. Initially it was homosexuality is a pathology that we need to treat. That's been debunked. Then it was homosexuality is caused by trauma. That's been debunked. Then it was homosexuality is caused by a relationship you have with your parents. That's been debunked.
So just on the very specific evidentiary question, are you representing then that if this went back, you want the opportunity to have a hearing to put in different evidence that it causes harm?
I think if there's some argument that we need to show that these studies were done on people who engaged in voluntary therapy, I think you could potentially go to the study authors and get that. But that particular critique was never raised. And again, I just think if what petitioner is saying is you have to have a randomized controlled trial on children in order to establish with respect to the particular thing that she wants to do, that would be, I think, a study that would, not even medicine would require a study like that to come up with a standard of care.
Justice Jackson?
Can I just quickly get you to address Justice Alito's question about how you distinguish NIFLA? You have definitely focused very clearly on the special relationship, the professional context, and the fact that this is medical care being provided in a counseling relationship. But as Justice Alito points out, we have addressed professional speech and the extent to which it should be treated differently, and it has said no. So how do you distinguish that case?
So professional speech, as it was addressed in NIFLA, is a much broader category than what we're talking about here. It would include things professionals are saying in any professional capacity. We are focused on the very narrow context where a healthcare provider is delivering healthcare to a patient. They are under fiduciary duties to act in that patient's best interest, and they are subject to malpractice liability. And that is just a different category.
So you're saying that this is a very narrow carve out, no matter what we sort of said otherwise with respect to professional, that you'd be advocating for a very narrow rule here.
Yes, it would be very narrow, and I think it's consistent with the precise doctrines that NIFLA called out as not triggering heightened First Amendment scrutiny, like malpractice, like informed consent, because those are things that are taking place in the exact same relationship that we're talking about here.
Thank you.
Thank you, counsel. Rebuttal, Mr. Campbell.
Thank you, Mr. Chief Justice. On standing, Justice Gorsuch, in response to your question, I heard the state say that they are not disavowing enforcement, particularly if the effort involves discussions that seek change on identity. On pages 216 to 217, Ms. Childs talks about how she wants to have full conversations exploring issues of identity and gender, and that includes considering change. On the issue of studies, there was a reference to the Green and Turban studies. All of those studies relied on bias sampling, self-reporting. They conflated aversive techniques with voluntary counseling. They did not isolate licensed counselors, and they did not purport even in their own study to prove causation. Beyond that, Justice Thomas, in response to one of your questions, the state conceded that it would be speech if it was a life coach, but it's for some reason not protected speech if it is a professional. That is an attempt to revive the professional speech doctrine that this court rejected in NIFLA. This law's viewpoint discrimination is even worse than we've heard so far this morning, because the state of Colorado would allow a 12-year-old without their parents' consent to enter into counseling that would go the opposite way on these issues of gender identity and sexual orientation. But if that same 12-year-old with their parents' consent want to seek counseling in the opposite direction, the kind that my client would provide, they are not able to do that. That kind of viewpoint discrimination must survive strict scrutiny. This law harms gender dysphoric kids because the statistics that we've cited in our verified complaint, as well as in the brief that we cited with this court, indicate that 90% of young people who are struggling with gender dysphoria before puberty work their way through it and realign their identity with their sex. But if one of those children go to a counselor and they specifically say, that is the help I want, realigning my identity with their sex, they cannot receive that help from someone like my client. Moreover, if they're continuing down the path of transition, then unfortunately they get locked into that path, and eventually it leads over 90% of the time, once they start down the path of social transition, it will lead to the route of medicalized transition, which the CAS report tells us comes with a lot of harm and devastation. And lastly, there should be no remand in this case for all of the reasons that I just explained. In addition to that, I heard Ms. Stevenson say that they were aware below that we were arguing for strict scrutiny and that they had an opportunity to put studies in. So all remand would do in this case is continue to prolong the ongoing harm that's happening not only to my client, but more importantly, the kids who are struggling with gender dysphoria.
Thank you, counsel. The case is submitted. We'll hear argument next in case 245774, Barrett versus United States. Mr. Larson.
Mr. Chief Justice, and may it please the Court. Possessing a gun in violation of 924C1A is a lesser included offense of using it lethally in violation of 924J. The offenses are therefore the same for purposes of double jeopardy, meaning there's a presumption that Congress did not intend two punishments for one fatal shooting. And this presumption controls unless there is a clear indication that Congress wanted to double punish. But there isn't any. As court-appointed amicus acknowledges, 924J says nothing about punishment under both statutes. And as detailed in our briefing, neither does 924C. On the contrary, while 924C is very clear that its punishment applies in addition to that for the underlying felony, it does not say its punishment applies in addition to that for a lethal shooting in violation of 924J. And the reason for this, as Your Honors explained in Laura, is that Congress designed 924J's penalties, which include life in prison and even death, to account for the seriousness of the offense by themselves, without incorporating penalties from subsection C. Indeed, as the Court also noted in Laura, when Congress wrote 924J in 1994, it specifically considered but rejected a proposal to impose multiple punishments for a fatal shooting. Only in 2005 did Congress write 924C5 to cumulatively punish fatal gun use, but only where armor-piercing ammunition is used, and that is not this case. In short, Your Honors, and as 924C5 confirms, Congress knows how to order multiple punishments for a lethal shooting when it wants to. It has not done so here. I welcome the Court's questions.
So, are you saying that all of 924C1 is a lesser included offense of 924J?
So not necessarily, Your Honor. If you're referring to things like machine gun use or use of a silencer, we recognize that question isn't presented here. We addressed it in one of our briefs, the scenario of voluntary manslaughter with a machine gun. And we say maybe those are different crimes. Maybe they're not.
What about 924?
As to that question, C1D2 is silent. It doesn't address it. And as the Court has explained, silence cannot be a clear indication to double punish.
And
Also, Your Honor,
what would be necessary, do you think, to make that clear?
what would be necessary would be something like what appears elsewhere in the statute. We have two examples in 924C of where Congress has ordered multiple punishments. One, it said if you possess a gun, you get a punishment for that in addition to the underlying crime of violence. It's also in C5 said if you use a gun loaded with armor-piercing ammunition to kill, you're getting a lot of punishment.
C5 came in much later. I mean, this was in 71, right? 924 C1D2 came in.
Yes, and even when it came in, Your Honor, in Simpson and Busick, this language was in the statute. And this court said in Simpson and Busick that this language, requiring a minimum, requiring it to be consecutive, was not sufficient to constitute a clear indication. That's why Congress had to amend the statute to make it crystal clear that it wanted to double punish both possession.
You want it to be in both 924J and in 924C, the provision that it can't.
Left side, left side. Left side.
Good afternoon, everyone. My name is Jim Campbell. I'm Chief Legal Counsel with Alliance Defending Freedom. It was my honor today to represent Kaylee Childs before the United States Supreme Court. I'm going to let her make a statement, and then I'll come back, say a few words, and answer any questions.
Hi, my name is Kaylee Childs, and I'm a licensed counselor in Colorado. I've spent my career using conversations to help people work through their struggles to achieve their goals. I've worked with clients dealing with trauma, addictions, and struggle with their gender and sexuality. I view my work as an outpouring of my faith. I want what is best for my clients, and often they seek me out because we have a shared faith. When I learned about Colorado's counseling censorship law, I was concerned about its impact that it would have on myself and my clients. Issues of gender and sexuality come up regularly with my clients in our counseling conversations. And Colorado's law would hover over every conversation I have with my minor clients, threatening me with a $5,000 fine, suspension from practice, and losing my counseling license. And while I certainly am worried about my livelihood, Colorado's law hurts kids struggling with gender dysphoria most of all. If counselors wish to engage clients on these issues, the law limits them to one option of encouraging kids to reject their body. That is a tragedy. Struggling kids benefit from access to voluntary counseling conversations that help them as they seek wholeness and gaining peace with their bodies. They deserve better than Colorado's one-size-fits-all approach. Today, my legal team at Alliance Defending Freedom told the Supreme Court that Colorado's law harms kids and censors speech. I'm hopeful that the court will see this clearly and protect free speech for me, for my clients, and for kids everywhere. Thank you.
Today we were able to make arguments before the court challenging Colorado's counseling censorship law. This law is blatantly viewpoint discriminatory. It allows counselors to help a child pursue the path of gender transition, but if a child instead wants to consider getting comfortable with their body and realigning their identity with their sex, this law says they can't talk to a licensed counselor in the state of Colorado. That's unfortunate because it's harming kids every day. There are kids struggling with issues of gender dysphoria, and this law tells them that if they're seeking help in one direction, that licensed mental health professionals and counselors are not available to them. As we made our arguments to the court today, the court seemed very receptive to the points we were making. The court acknowledged that Colorado is trying to censor private conversations between licensed professionals and their clients. Specifically, that would be in violation of what this court said just a handful of years ago in the NIFLA versus Becerra case, where the court recognized the harms of censoring private conversations between counselors, doctors, and their clients. The court gave many indications that it was bothered by the law. It seemed to me that the court views this, at least many members of the court views this, as a viewpoint-based law. And under the First Amendment, Colorado is not allowed to censor viewpoints based on which side of the aisle they fall on. With that, I'll take questions. Hearing none? Oh.
What would you say about Justice Kagan? What do you think? Where do you think she may stand on this? She seems to agree with various points made by the ADF.
I do think Justice Kagan was receptive to many of the responses that we gave, but I'm not sure where Justice Kagan will land in the end. Yes.
I'm just curious, what is your response to the critics that say that conversion therapy doesn't work and that it is harmful in the long run?
What Kaylee Childs does is provides voluntary conversations to help minors pursue the goals they've set for themselves. When people talk about things like conversion therapy, they're not talking about the kind of consensual, caring conversations that Ms. Childs provides.
Well, then would she also then help them become comfortable if they decide that they are gay or transgender?
Yeah, she's never been asked to do that, and so that's not a question that she's ever faced.
You mentioned during arguments that Ms. Childs faced several anonymous complaints in the past couple weeks. Can you elaborate on that?
Yes, over the course of the last few weeks, there have been numerous anonymous complaints alleging that Kaylee Childs has violated the very law that we're challenging here. And rather than dismiss those complaints, the state of Colorado has sent them to Kaylee and are now demanding that she responds to them. So that just heightens the fact that the state is willing and in fact in the process of exploring the enforcement of this law against Kaylee Childs, and that makes it abundantly clear that we have standing in this case. Thank you.
I hope they're coming.
Good morning. This is Colorado Attorney General Phil Weiser. He'll give a few remarks. We also have members of the legal team coming up and joining. Shannon Stevenson, our Solicitor General. Shannon, everybody come over here, please. You want to stand behind the Attorney General? Okay.
Today, the Supreme Court heard arguments in an important case around what is a practice that's harmful, that's banned on a bipartisan basis in Colorado and many other states. It's telling young people that who they are is not okay, leaving lasting harm. This type of pressure, coercion, has been disavowed, discredited by all medical associations. In the United States of America, since the founding, we've had systems to protect patients. There's a fiduciary relationship when a licensed professional subject to malpractice tries to help someone. And it means they need to be doing things that are helpful, not things that are shown to be harmful. The idea that there could be a First Amendment exemption to this is dangerous, can create a lot of mischief. We've made our case to the Supreme Court. We'll now wait on an answer. And if you have a question or two, I'm happy to take one.
Ms. Child's attorney said during oral arguments that there are several anonymous complaints that have been submitted against Ms. Child during the past few weeks. Can you address that?
One of the challenges about this case is the petitioner has put in no evidence into the actual record. If you look at the evidence in the record, it's all put in by the state of Colorado, showing how these practices are harmful. There have been no official proceedings or efforts to take any action against the petitioner. And now, even at the Supreme Court level, they are stating for the first time information that's not in the record, that there's no evidence of, and there's no basis to actually evaluate it. This is not how the Supreme Court should be making decisions. There should be an actual record with facts that have been considered.
Child's team is saying that this is an attempt to censor private conversations. Could you address that and talk about your argument against it?
The long-standing regulation and oversight of medical professionals is treated specially for good reasons. People hold themselves out as professionals who are operating based on a standard of care so the public knows they can trust them. That's very different than private conversations about matters that could be of public or scientific concern. When you're a licensed professional, you have special responsibilities. That's why we have licensing. That's how we have malpractice. This is a very different situation than people sharing their ideas on issues of public concern.
Ms. Child's team said that she's never been asked to affirm a child's gender or sexual orientation. What do you think that says about the kind of services she provides?
I don't know what type of services she provides because we don't have any evidence of what she is exactly doing. And that is a real problem in this case. This has been a little bit of a moving target.
The justices seem open to the argument about strict scrutiny, and I'm wondering what your reaction to that is and how that would impact Colorado law in your case.
We will see where the Supreme Court chooses to resolve this case and then how to defend our law. Our job will be to defend our law to the best of our ability, and whatever the court does, we're going to continue to do that. Thank you all very much.
agree with somebody later. Are you in town here?
Sherry, you want to move over to this?
Yes. Sorry, guys.
Next time you'll let the pool. Be one less thing you have to worry about.
It is. Sorry about that.
You need to apologize. You've done
Yeah.
nothing wrong, Colorado.
I'd leave it with someone, meet up with somebody later.
Yeah, we don't know.
How's Lenny? Lenny, this guy, huh?
Who's Lenny?
That's yours? Oh, yeah.
He's not Lenny, but Lenny made
Yeah, I know Lenny made I don't get credit for this invention.
I know Lenny. I met Lenny. I work with him.
I hear John says he's retired.
Yeah, Lenny's
You were
retired.
smarter than us, huh?
Lenny and I worked in Miami together.
Did you?
Yeah.
Leave Davalos.
Leave Davlos.
Ah! Small world.
Small world, brother. I work with Lee.
Yeah, we talked that last time.
Yeah.
You got it. Thank you, sir.
Yeah. I just use that to hit people in the head with.
Yes. Yes. Okay. Fingers simply just fast. Hey, Sarah. Call Lisa. Hey, Sarah. Hey, Sarah.
So he said, hey, Sherry. I'm like, what?
Man. I'll take that.
Hey, Sarah. Call Lisa Lynn. Yes, ma'am. Mm-hmm. And there you go.